Hello, everyone. Welcome to Washington Gun Law TV. I'm your host, Attorney William Kirk. Today, I want to spend a few minutes talking to you all about the laws of self-defense here in Washington State. What we're going to do today is we're actually going to talk about self-defense in a couple of different ways. We're going to talk about self-defense in general. We're also going to talk about self-defense when it involves the use of lethal force, because the law in Washington is clearly different depending on whether or not you're using lawful force or whether you're using lawful lethal force. And there's an important distinction that we're going to need to discuss today. But hey, before we get into that, just want to let all of you know, if you ever have any questions about gun laws here related in Washington State, all you need to do is reach out to us at washingtongunlaw.com. That's washingtongunlaw.com. That is the home of Washington State's lawful and responsible gun owner. Go ahead and visit us there or follow us on Facebook. So let's talk about self-defense in general. First of all, in Washington State, a person is allowed to use force reasonably necessary in order to defend themselves. Now, the exact statute is RCW 9A.16.020, and that statute specifically states that the use, attempt, or offer to use upon or towards the person of another force is not unlawful in the following cases. And the statute lists several types of areas in which lawful force would be used. But the one which is most likely to apply to you, the viewer, is this one. Whenever used by a party about to be injured or by another lawfully aiding him or her in preventing or attempting to prevent an offense against his or her person, or a malicious trespass, or other malicious interference with real or personal property lawfully in their possession, so long as the force that is used is no more than what is necessary. And that is really the key thing that I want you all to take away from this. Lawful force is allowed to be used whenever a person believes that they or another person in their presence or their use of real or personal property is an imminent threat. However, the use of force used cannot be more than what is necessary to repel that threat. Consequently, a person is engaged in some sort of a fist fight, a shoving match, something to that effect. It is not escalating beyond that. They pull a firearm out and fire a shot, seriously wounding the other person. While they had a right to defend themselves in that situation, they did not have the right to use lethal force in that situation, because that is far more than what was necessary in order to repel that threat. And that's a really important distinction when we talk about defending property, especially in this particular time and era where we have general lawlessness in the general Puget Sound region. We have our police departments being defunded. We have political groups out there or who claim to be political groups who really want to do nothing more than destroy property. And so the question is asked often is, can a person use lethal force to defend only your property? Another example is you find someone breaking into your car in your driveway late one evening. Can you use lethal force in that situation? And I think the law in Washington State is very clear, and I want to make this very clear to you as well. And the bottom line is this: lethal force can never be used to defend only property. Let me say that again. Lethal force can never be used to defend only property. Lethal force can only be used when the person threatened both objectively and subjectively believes that they are in imminent risk of death or serious bodily injury. Let's talk about when actually lethal force is justified, okay? Homicide is justified under RCW 9.16.050 in instances where, in lawful defense of the slayer or their spouse, parent, child, brother, sister, or other person in their presence, when there is reasonable ground to apprehend a design on the part of the person slain to commit a felony or to do some type of great personal injury to the slayer, and there is imminent threat of that being accomplished. Now, that is the legislature coming out with a whole bunch of legalese language trying to describe when you can use lethal force. But the bottom line is this: lethal force can only be used when the person believes that they are in imminent threat of death or serious bodily injury. Let me repeat that. When you are in imminent threat of death or serious bodily injury. And then and only then does that force become necessary. Now, let's talk a couple minutes about how does our statutes define what is necessary. Well, RCW 9A16010 defines a couple of these terms. Necessary, under Washington legal definition, means that no reasonably effective alternative to the use of force appeared to exist at that moment that the force was reasonably used, and so long as the force was used to affect the purpose of it. That is, if you intend to defend yourself against person A, and upon doing so, then turn that force upon person B and person C, who had nothing to do with the perceived threat, your use of force against person B and person C may be without lawful justification. Now, deadly force is also defined by the same statute. Deadly force means the intentional application of force through the use of a firearm or other means reasonably likely to cause death or serious physical injury. Again, a bunch of legalese, but what does that mean to you? Deadly force is the use of any type of force which could reasonably lead to serious injury or death of the person the force is being inflicted upon of. The use of a firearm is obviously the most common, but deadly force can be obviously implemented through many other tools of destruction. Moreover, and this is really important under Washington law, pointing a firearm at a person is considered the use of lethal force. Let me repeat that again because it's important. Merely pointing a firearm at a person in most instances would be deemed the use of lethal force in the state of Washington. I have said to many people who've contacted Washington gun law that if you are lawfully justified at pointing a gun at a person, you are actually lawfully justified at pulling the trigger at that moment. And so that should give all of us pause as to the quantum of proof, which is really necessary before we get to actually point a firearm at another individual, let alone discharge it. And so the warning shots, firing a shot into the air, firing a shot into the ground, if you're not encountering an imminent threat of death or serious bodily injury, that is an excessive use of force and is likely going to land you in a lot of trouble with the law. Okay, let's talk about a couple of the exceptions to Washington's self-defense laws because it's important that you familiarize yourself with that. The most common exception is what's called the first aggressor standard. Now, there is no RCW. You're not going to find anything in the revised code of Washington which talks about the first aggressor standard. Rather, it is a jury instruction which is given to jurors in self-defense assault type cases. The jury instruction itself reads that no person may, by any intentional act reasonably or likely to provoke a belligerent response, create a necessity for acting in self-defense or defense of another, and thereupon use or offer to use force towards another person. The jury is also instructed that if you find beyond a reasonable doubt that the defendant was the aggressor and that the defendant's acts and conduct provoked or commenced the fight, then self-defense is not available to him. What's that mean in layman's terms? Well, it means that if you pick the fight, if you are the first aggressor, if you're the one that starts the conflict, and then later in the course of that conflict believes that you now need to defend yourself by some legal means, there's a strong likelihood that self-defense will not be available to you. Okay, let's talk about another exception to Washington State self-defense law. And this one, I will admit, is pretty unique to Washington State. I think it speaks volumes about the political climate that we operate in or have operated in for a number of years. And so I'm going to read to you RCW 9A.16.025, the statute entitled Use of Force When Unjustified, Victim Identity. The statute reads as follows. A person is not justified in using force against another based upon the discovery of, knowledge about, or potential disclosure of the victim's actual or perceived gender, gender identity, gender expression, or sexual orientation, including under circumstances in which the victim made an unwanted, non-forcible romantic or sexual advance towards the defendant, or in which the defendant and victim dated or had a romantic or sexual relationship. Now, I'm not going to get into all the hypotheticals that we could use in this particular example. But under Washington law, it is pretty clear that discovering that an individual is a gender other than what you believed in almost all circumstances will not provide a basis by which you can inflict force upon them in the act of self-defense. And that apparently, according to this statute, even means when the victim has made unwanted, non-forcible, romantic, or sexual advances towards the would-be victim. So take that for what it's worth. It is the statute. Again, the statute is 9A.16.025. So I want to talk to you guys here finally about the importance of self-defense from a legal perspective. Now, obviously, you all recognize that self-defense is an important legal tool that can actually exonerate you of very serious criminal charges, so long as the force that you use is proportional to the force which you were trying to repel. But the other reason that prosecutors have a tendency to perk up when they hear about valid self-defense claims is that RCW 9A.16.110 requires that the prosecution reimburse a defendant if they are found not guilty by reason of self-defense. The statute specifically reads that no person in the state shall be placed in legal jeopardy of any kind whatsoever for protecting by any reasonable means necessary himself or herself, their family, or their real or personal property for coming to the aid of another who is in imminent danger of assault, robbery, kidnapping, arson, burglary, rape, murder, or any other violent crime defined by statute. More importantly, the statute says that when a person is charged with a crime listed in subsection 1 of this statute and is found not guilty by reason of self-defense, the state of Washington shall reimburse the defendant for all reasonable costs, including loss of time, legal fees incurred, and other expenses involved in their defense. Now, for any of you who have ever been involved in a serious assault case, you recognize that it oftentimes takes multiple lawyers to defend an individual who's looking at assault in the first degree, murder in the second degree, or anything like that. And legal fees can easily run 6 figures on cases like that. So obviously, with a valid self-defense claim, prosecutors have a tendency to be very cautious about proceeding to trial on cases such as that, because not only does the defendant have a wonderful opportunity to obtain an acquittal at the end, but it could turn out to be incredibly expensive for the prosecution down the road. Well, I hope that helps you better understand the laws of self-defense here in Washington State. Listen, part of being a lawful and responsible gun owner is knowing every law, how it applies to you in every situation. You may have some more questions, and that's fine. Feel free to contact us at WashingtonGunLaw.com, or you can always give us a call at 425-765-0487, or follow us on Facebook. Until next time, thanks for watching Washington Gun Law TV, the home of Washington's lawful and responsible gun owner.